The question is, quis custodiet ipsos custodies? This is a famous Latin phrase meaning who guards the guardians? And that's the question for this video. Are our intelligence organizations and the FISA Court preserving our rights, protecting our freedoms and our privacy? Let's take a closer look at that, and we'll see what conclusions we come to. Join me in the struggle for knowledge, the battle for truth. I'm Stephen Arms, and welcome to The Foreign Intelligence Surveillance Court was established in 1978 by Congress. The court sits in Washington, D.C. and is composed of 11 federal district court judges who are designated by the Chief Justice of the United States. Each judge serves for a maximum of 7 years, and their terms are staggered to ensure there's a continuity on the court. By statute, the judges must be drawn from at least 7 of the United States judicial circuits, and 3 of the judges must reside within 20 miles of the District of Columbia. The judges will typically sit for a week at a time, rotating through. Pursuant to FISA, the court entertains applications submitted by the United States government for approval of electronic surveillance, physical search, and other investigative actions for foreign intelligence purposes. The court's work is conducted ex parte. Again, it's a Latin term, on one side only. Ex meaning out of, and parte meaning a piece or a part. Meaning that it doesn't, when it puts forth its applications for warrants, there isn't any opposition to it. It's only one side being provided. This is argued that is needed because to protect the classified national security information put forth in these warrants. The Foreign Intelligence Surveillance Court is no longer properly serving its constitutional purpose in providing a check for the executive branch's ability to obtain U.S. citizens' personal communications. Technology has particularly changed the role of the FISA Court from its original simple reviewing of government applications for collection of communications on specific cases. It can now be used to issue blanket approvals of data collection programs that can affect millions of Americans. Under today's foreign intelligence surveillance system, the government's ability to collect information about ordinary citizens has increased exponentially. The law remains the same, but the ability to acquire the information has grown, and therein lies part of the problem. I do not believe that the FISA Court currently meshes with the Constitution at this point, particularly the Fourth Amendment. The Fourth Amendment of the Constitution guarantees the right of the people to secure their persons, houses, papers, and effects against unreasonable searches and seizures. Privacy today is more of a cultural than a legal concept in the United States. Americans aid and abet their loss of privacy, though, to be fair, because of the internet and credit cards, smartphones, social media, all the various ways that big data is collected by commercial organizations and misused. In a sense, we as Americans, some particular Americans who are very involved in social media, are placing their lives on public display. If you're going to put your naked butt on display, then do not get angry if people look at it. But surveillance by the government is another matter. It is logical to distrust a government who is collecting your data. One administration may be operating lawfully above the board, but what about the next one? What people have to think about is that a real threat of tyranny is always possible, and it can come from a desire to protect as easily as it comes from a desire to control. Going back a little, let's consider the Omnibus Crime Control and Safe Streets Act was created in 1968. You go, well, so what? Well, it was established basically the rules of the domestic government's restrictions on surveillance and wiretaps. 10 years later, the FISA Court is created, and it focuses on foreign intelligence, but it can be used easily to abuse because to allow for unreasonable surveillance. There have been several individuals, Eric Lichtbau comes to mind, James Risen, and though I'm not a big fan of him, even Edward Snowden decisively made a point that our government was abusing its collection of data. So even if the judges and those who apply for the FISA courts are professionals, in the aftermath of 9/11 and through the use of the Patriot Act, FISA can virtually have unrestrained domestic spying by organizations like the FBI. Over its 33-year period, the FISA court has granted, at least at my last count, 33,942 warrants. It has only denied 12. Now that's a rejection rate of 0.03 of total requests. If you have 0.03 of anything, statistically from most points of view, it's considered to be not at all. So to say the FISA court is a rubber stamp makes rubber stamps jealous, because no rubber stamp can make 34,000 stamps and only have 12 that are not going to come out properly. The problem one of the problems also with the FISA court is it makes its own rules and it operates in secret. It relies on what's considered a general heightened duty of candor, is the phrase they use, meaning that the government is supposed to go to extreme lengths to give the court every bit of information it needs to make the right decision. Now, if this is a simple process of approving applications for surveillance, the evidence could be later challenged in court, that would make sense, but the process is not so simple. And it involves critical issues of constitutional law and interpretations of what Congress actually meant in the original FISA law it created. The court is relying on this one-sided information from the government, and it has to trust it entirely. And the court itself has complained that organizations such as the NSA and the FBI have made mistakes in the past and have been, though they've only turned down 12 warrants, about 2.5 times that they've had to edit. It's still functionally way less than 1%. The problem is with FISA, well, I think basically, in my opinion, there's three major problems with FISA, and I may be repeating myself a little, but let's go over them again. FISA has become drastically more complicated than the original law that was put in place in '78. And because it has grown beyond its bounds of what Congress originally created it for. That's first. Second, because of these changes, FISA has created a huge body of legal precedent and policies that are secret. And third, the court's reliance on the government to provide all the information is not sufficient. Now, I did a little thinking about this and I did a little research, and I believe the court needs to basically be changed in 2 ways, in my opinion. I'm not a lawyer and I don't play one on TV or even on the internet, but I have done research and I do read legalese. So I'm of the opinion the 2 ways it should be changed. One is a need for a true advocate for privacy and civil liberties in the court. And I'll explain what I mean by that. And second, that there must be some form of institutionalized, systematic publication of its significant opinions and decisions. Okay, first, creation of an advocate for targets of surveillance, as well as for privacy and civil liberties. The way the court is now, the government puts forth its evidence and the judge rules on it. If you had an advocate in there, especially in the matters of privacy, they could move the court toward a more adversarial model. They would not, the judges would not have to have blind reliance on the government's truthfulness on issues. The opposition could challenge it. And a special advocate could also bring technical expertise that the FISA court might not otherwise have. and they could help them spot legal issues and other problems that might go unnoticed. You could probably pull these advocates from a variety of places. Attorney generals of states might be good choices. Members of the of House Judiciary or Senate Judiciary committees might actually come in and do that. There's a variety of legal experts that would probably have no problem coming in and just arguing for the Constitution and the rights of individuals. Now, proponents of the FISA Court would tell you, well, this will slow it down. And I go, yes, it might slow it down a little bit. But on the other hand, I don't think that the wheels of justice need to be careening on so fast that we're going off the cliff. Maybe just a good fast speed would be enough. Second, I believe that a publication of the significant interpretations of the law are essential. The public would need to have an understanding of what laws are mean and what is being put in practice by this court. Declassification now is handled by the intelligence community. And I'm sorry, but I trust, if you ask me, do you trust the members of the intelligence community? I'd say yes. The vast majority of them, I think, are good, hardworking, patriotic people who are doing what they can for this nation. I believe the same thing about police officers. But there's a difference between a beat cop and a police commissioner. And there's a difference between a field agent and the head of the FBI. The head of the FBI is an administrator. And in my opinion, I have known dozens of administrators in my life, and I only know two that come to mind that I would trust. Administrators in general, I believe, become political entities, and politics sometimes gets in the way of the truth. In the case of the publications, at the very least, the Attorney General and the FISA Court itself should be able to get together to determine what opinion should be published. And they could create a set of guidelines of what significant interpretations of the law actually are. Now, if the matter is heavily classified, you could create a non-compromising summary of the decisions and interpretations of the court. And this gets into current news, because all of the idea, this would be the Republican memo that came out about a week ago. Devin Nunes is the chairman of the House, well, get it right, the United States House Permanent Select Committee on Intelligence. Now, Congress can't do anything simply, can they? He put forth a memo of issues that they had dealing with the current, with a FISA warrant that had been directed against the Trump administration. I'll go into more details on that. But I'm not sure I would believe Devin Nunes entirely, because Devin Nunes strikes me as he might be a decent man. I don't know him, but he's very partisan. I wouldn't trust him entirely. I'd check his facts. Personally, if Chuck Schumer told me something, I'd check his facts too. When people are so partisan that their logic can be compromised by their fanaticism. But in the case of this Republican memo, I do know that it was also supported by Trey Gowdy, who's a member of the United States House Permanent Select Committee on Intelligence. And Trey Gowdy's probably the best lawyer in Congress, and I've never heard anyone say that he's not a straight shooter and an honest man. So if he didn't have any problem with the memo, I tend to lean toward I'm believing that what's mostly being said here. In summary, what they did is the FBI basically used an unverified, allegedly biased document they known as the Steele dossier. They used it to get a warrant in October of 2016 because they wanted to do surveillance on a man named Carter Page, who was a former Trump campaign advisor. The dossier was prepared by a former British spy whose name is Christopher Steele, and it alleged that there was a conspiracy between Trump and the Russian government. So again, the Russian investigation that we've been talking about for the last year and a half now. The problem is the Steele dossier was financed by the Clinton campaign and the Democratic National Committee. It's what would be referred to as opposition research. And the memo argues that this is a major problem. Senior members of the FBI and the Justice Department knew that the Steele dossier was indirectly funded by a lawyer of the Clinton campaign and the DNC. And they didn't disclose it in their application to the FISA court for a warrant. Now, of course, since the court approves these warrants, they are supposed to give all pertinent information. They did not consider this to be pertinent. Again, this is why an opposition person, an opposition advocate, would immediately have solved this problem. They also didn't disclose that when they renewed this application on several occasions afterwards about this surveillance. Now, this dossier had been pretty much discredited. Steele himself even said that when he testified in Great Britain on the matter, that he couldn't fully verify the information in his dossier. It's probably just Russian propaganda recycled through. And you go, well, that's kind of mean. Why would he have done that? Well, in September of 2016, Steele spoke to the Deputy Attorney General, who is Bruce Orr. And Steele told Orr that he was desperate that Donald Trump not get elected and was passionate about him not becoming president. So obviously he had a reason why he'd be willing to doctor his dossier, shall we say at the least, to be generous. Also, this was significant because the Deputy Attorney General's wife worked for a research firm which is called Fusion GPS, and they're the one that hired Steele on behalf of the DNC lawyer to make this dossier. So it's a little bit complicated, but I think that kind of brings it out. Now, I will point out to you at this point that I am not personally, I did not support Donald Trump when he ran for the presidency of the United States. But he is president now, and I support the president of the United States when they're put in office. I supported Barack Obama, I supported George Bush, I supported Bill Clinton, and I wasn't terribly fond of either of them and didn't like most of their policies. But I do need that, so I'm just letting you know that I don't have a huge dog in this fight. I do believe, though, the problem here is the misuse of the FISA Court. And if it can be done to do something like this, then it puts us in a position that do you really want intelligence agencies or people that are members of the deep state? People, we hear that term deep state. The deep state refers to people who work in the federal government who are not elected. They've been appointed. Heads of FBI, heads of large sections. You know, a lot of these individuals work for the government as jobs, and they don't. They're put into the position, and they sometimes administrators come, as in presidents come and presidents go, congressmen come and congressmen go, and you still have the same director, the same person working in the government. And the point is that these people have access to the FISA Court. Do you really want them determining our politics in this country? That if the American people elect somebody, should their decisions be able to be undermined or set aside because of individuals wishing to abuse the system? And that's my problem with this. I believe that we do need to have mechanisms in place to help protect our security because it's a dangerous world. But I also know that I'm not so sure I want to sacrifice my freedoms and rights, especially my rights to vote and elect officials in this country, because we have individuals who wish to put their own opinions forth by misusing the system and abusing justice in this country. Well, let me know what you think about it. You, of course, can mark the likes, make comments. I appreciate it. Subscribe. So thank you for your time, and battle on.